commit an offense by relying on the misrepresented facts to grant a loan. Do you get the explanation? All right. So that is a matter of contract. However, if you look at what happened in the Wontumi case, it's beyond. Okay, so there are two forms of misrepresentation. You can have a fraudulent misrepresentation that borders on criminality, all right, that borders on fraud, okay, that can lead to prosecution for defrauding by false pretenses, all right, and the criminal liability is on the person that made the fraudulent, misrepresentation and not the fraudulent representation and not the bank. So you cannot hold the bank, to a criminal, for criminal accountability in respect of it, because the bank relied on the representation. You can say that it was not diligent. They should have conducted their own due diligence in order to be able to, act prudently and not give the loan to a person who actually does not intend first to use the loan for the purposes for which it was contracted, and secondly, basically wants to defraud the bank. All right. So banks cannot be held, criminally liable because they have relied on those misrepresentations made by persons who are seeking, loan facilities from them. Now, the third question relates to the issue of plea bargaining. And I do not want to walk myself into any trouble. All right. I have stated, and time without number, that the law allows persons who intend to plead guilty and make restitution to do so. So those of you who are, I know some of you are attempting to be lawyers. Others are also pocket lawyers. You can, I'm talking about the journalists who sometimes report from the court. You can look at Section 35, all right, of the Courts Act, okay, especially where they can decide that they want to plead to a lesser offense, all right, pay back the monies in the case of, Chairman Wontumi, in excess of 24 million Ghana cedis, all right, and then they'll be given a suspended or custodial sentence. In the case of Akpalu, the same, can happen. So the plea bargaining statutes allow them to take advantage of that. But I am the Attorney General. I am the prosecutor. I am not defense counsel. So it is not left to me to advise them what to do. In fact, what I want to do is make my case to the court, prove beyond reasonable doubt that they have committed the offenses that I'm charging them with, all right? And if the court finds them guilty, it will sentence them to prison terms for what they have, for the wrongs that they have committed, all right? That is my strategy. But because this is oral, I think sometimes the tendency is to say, talk about recovery, all right? But we can do recovery post the sentence. If someone has been sentenced, I can still go after their assets. And in the case of Wontumi, one of the things that I forgot to say is that we actually froze his assets, including a 50 million CD account, that belongs to a company of his, an insurance company of his that we froze. And so it's easily, it's possible for me even now, all right, to take steps, to recover in a civil action using the EOCO, Act, okay, to recover the 24 million, that was taken from Exim Bank, right? So for me, it is left to their lawyers to decide the path that they want, to tread. If they want to defend the action and then get to trial and then be pronounced guilty or not guilty, it's left to them. If they also want to short-circuit the process by plea bargaining, it is left to them. I would not advise them. I would not be the one to proffer that advice. So thank you very much.
quick update on the National Cathedral. We heard Domahini yesterday speak about or express his revulsion at the whole state of affairs of the National Cathedral. What is the state of the forensic audit that His Excellency the President asked you to do?
Thank you very much. So the forensic audit, as you rightly pointed out, was at the direction or command of His Excellency the President. After he met with myself and the Auditor General, and I think the Finance Minister. Subsequently, we had a meeting at the Ministry of Finance where it was decided that we should speedily get a private audit firm to do the forensic audit. Now, I cannot procure, usually if I'm procuring services, it will be legal services. All right. There's no precedent of an Attorney General procuring non-legal services. And because this is audit and will be supervised by the Auditor General, it was the Auditor General who was given the task by the Minister of Finance to proceed to procure the services of an audit firm to conduct the forensic audit. And Pricewaterhouse was, chosen to do this work by the Auditor General. The last time I checked, they had actually written to my office, this was last week, they had written to my office that they are coming, they want a meeting with me to understand to understand some of the issues that are germane to the forensic audit that they are conducting. Now, that doesn't mean that they've done significant work and they are, getting to the end of their work. But they want some of the stakeholders, such as myself, all right, to have a conversation with them regarding the work that they are doing. So very soon, I want to assure Ghanaians that very soon we will have the report of the forensic audit conducted by PwC, and that will let us know whether or not any wrongdoing had taken place.
Last one or one and a half. You've mentioned public officers being surcharged, but I'm also looking at the Auditor General's report. We keep hearing a lot of financial misapplication. What happens to those reports or afterwards? And then regarding the plea bargain, you also spoke about people have approached for plea bargain. We keep hearing it that consistently. We are going for Christmas. How much so far would you say you have been able to garner? Maybe we can use some for Xmas. Thank you.
Yeah. Okay. So the Auditor General report, as you rightly pointed out, is usually replete with acts of malfeasance by public officers. And then most of the time, they appear before Parliament. They are queried on those acts of malfeasance or audit findings, and then some of them are able to come up with evidence that they either did not, they either did not commit the malpractice alleged, okay, or that they have since remedied the situation. All right. Now, that is within the remit of the Auditor General. The power to surcharge and to disallow and surcharge is a power granted under Article 187 of the Constitution to the Auditor General. So he alone can disallow and surcharge. All right. I come in, or my office comes in, at the point where we have to take action to recover. We have to take legal action to recover. And that is where we can come in and take the action, based upon the disallowance and surcharge notices to recover from the persons who have been, surcharged. Yes, and then talking about recovery, offers have been made, as I've said. In some cases, in the National Service case, for instance, one person offered to pay 22 million Ghana cedis, okay, out of, I think, 30-something, about 38 million, and I rejected the offer. All right. So, yes, offers, keep being made, but sometimes The offers are made conditional on people just bringing the money and walking away, and I say no. So that is where we are. That is why we haven't recovered. But we will certainly recover, and we will recover a lot of money. So thank you very much.
Thank you very much, Honorable Attorney General, for that concise briefing and your crisp responses. So we will draw down the curtains on today's edition, and in fact, this year's edition, unless something of biblical proportions happens before the end of the year. So to all of you who have been part of the success of this program throughout the year, I extend sincere thanks to you. I hope to see you next year. Merry Christmas to all of you.
Formally transmitted the request for the extradition of former Finance Minister Ken Ofori-Atta and his chef de cabinet, Mr. Ernest Dako Akore. You will recall that the Office of the Special Prosecutor investigated acts of corruption and corruption-related offenses by the former Finance Minister and his accomplices, and proceeded to file charges in the High Court of Justice against them. On November 19th, 2025, that is this year, my office received a formal request from the Office of the Special Prosecutor to initiate extradition proceedings for Kenneth Ofori-Atta and Ernest Dako Akore from the United States of America. Following a preliminary review, our International Cooperation Unit observed that certain aspects of the request require clarification and enhancements to align with the applicable legal and procedural requirements. We communicated these observations to the Office of the Special Prosecutor via a letter dated 25th November 2025 and requested supplementary documentation to ensure completeness. On December 9th, 2025, the Office of the Special Prosecutor provided the requested additional documentation and addressed the observations that we raised, thereby finalizing the extradition request packages. Subsequently, on December 10, 2025, my office transmitted the complete request to the Ministry of Foreign Affairs for onward transmission to the competent authorities in the United States of America. That is, in this case, the Department of Justice of the United States. At this point, it is left to the American authorities, especially the judicial authorities, to make a determination on whether a sufficient basis exists for the two accused persons to be extradited to Ghana to stand trial. And because the matters have already been filed, and because they have been filed by the Office of the Special Prosecutor, I am not permitted to go into the details of the charges. But the charge sheet is a public document and has been made available, and all of you, I'm sure, have access to it. There are 78 charges against Honorable Ken Ofori-Atta and his accomplices, and they border on causing financial loss to the state, using public office for private benefit, and so on and so forth. So you can look at the charge sheet and then make up your minds with respect to the charges. So I won't comment on them in today's press conference. Basically, what I want Ghanaians to know is that this government is committed to accountability, and the government has taken the requisite steps that are legally required for the Honorable Ken Ofori-Atta and Ernest Dako Akore to be extradited to Ghana, to be brought to Ghana to face justice. As I indicated earlier, it is now left to the judicial authorities in the United States to assess the entire package that we have presented to find out whether there is sufficient basis for him to be extradited. But as I mentioned earlier, the major announcement that I have this morning is in relation to an investigation conducted by the Economic and Organized Crime, which led to a very big recovery of proceeds of crime. As you are all aware, the Economic and Organized Crime Office is one of the key law enforcement agencies that works directly under the Office of the Attorney General. Since assuming office as the Attorney General, I have worked closely with the Executive Director of the office, that is EOCO, Mr. Raymond Archer, and the management and staff of the EOCO to ensure that the fight against economic and organized criminal enterprises is sustained. The investigation I'm about to announce and the results of that investigation demonstrate the commitment of the Economic and Organized Crime Office to the fight against organized criminal enterprises. The investigation, which by the way is still ongoing, was complex and at the same time groundbreaking. In or around fraudulent investment schemes, the gang established a Ghanaian company in 2019 to front their criminal enterprise. According to official records obtained by the Economic and Organized Crime Office, the company's principal business by paying a registration fee. Once the victims signed on, they were encouraged to purchase investment packages